welcome to Legal Connect on iBrandTV. My name is Margaret Opera. On today's show, we'll be discussing employment laws in Nigeria. We have a guest on the show, but you meet him after the short break, so stay with us. Many thanks for staying with us. This is still Legal Connect on iBrandTV. As I said earlier, we have a guest on the show in the person of Tayo Oluwole. I'll just read a brief some things about him. Tayo Oluwole is a managing partner and CEO, Mark Timothy Associates Consulting Limited Liability Consulting. Oluwole has had a formal education and training in business management, international business, corporate administration, marketing management, project management, and insurance and risk management from Imo State University, Wisconsin University, Wisconsin International University, Chartered Institute of Administration, National Institute of Marketing of Nigeria, Project Management College, UK, and West African Insurance Institute in the Gambia. He's also a professional studying member of the Institute of Leadership and Management in the UK and an associate of the Chartered Institute of Administration and National Institute of Marketing of Nigeria. Tayo, you have an interesting profile there. Thank you for being with us on the show today. Thank you for coming.
It's my pleasure, man.
Having someone like you on the show with such a huge profile, we don't get to see this all the time here. All right, then on today's show, we're discussing employment laws in Nigeria. Now, I understand that the Nigerian Labour Act is the primary legislation which deals with the relationship between employers and their employees. So, would you have you tell us about some of this employment laws in Nigeria?
All right. Generally, or by way of saying fundamentally, the employment law in Nigeria, also known as the Labour Act, is what regulates the relationship between employer and employee, that is, companies or businesses and their staff generally. It is a normal provision, or what you call fundamental provisions, that a relationship exists between an employer and an employee, and as such, there needs to be legislations or act that regulates such terms and conditions of employment. That's basically what it is. Okay, yeah.
And I understand that the types of employment laws include the civil rights, family and medical leave, workers' compensation and labor relation laws. And other type of employment statutes include workplace safety, compensation and child labor, immigrant and employment statutes. So some of these employment laws, do you think some of the employers in Nigeria are actually going by these laws I just listed out now?
Well, it is expected that any enlightened employer of labor must comply, must know what the Labour Act or employment law in Nigeria is about. Failure to do so is an attempt to start committing suicide for your business. So whereas we cannot categorically guarantee that everybody in Nigeria who have staff or who employ labor are currently complying, okay, but by default they are expected to know and they are expected to comply. Okay, so if you want to run your business in a sustainable manner, you must have knowledge, or at least have professionals who have knowledge of the employment law and run your business in compliance with whatever is the provision of the labor law.
Okay, so these employment laws, what is it and whom is it meant to regulate?
As I earlier hinted, the employment law is the Labour Act that regulates the relationship between the worker, that is the staff of an organization, also known as employee, and the employer. So it is expected to regulate the employer who give work or who give, job to the employee, and at the same time it's expected to regulate or gives, the right and responsibilities of both parties, that is both the employer and the employee, basically.
Now the term employee, what does it mean in the legal parlance, and how does it reflect in the application of employment laws? That's the term employee.
Okay, the term employee, simply put, is anyone or person or group of persons who make themselves available to offer or render service to an organization or a business enterprise. So, also known as worker, also known as staff, as the case may be. So, if you have certain skills, or you can render service to an organization, and the organization agree to hire you to render that service and pay you in return for that service, you are an employee.
Now, I understand that there are types of employees. Now, we have the contract staff and also the full staff. Now, the concept of contract staff now, what extent are they covered by the law?
Well, the law cover everybody who has to render service. Now, the contract staff simply mean those categories of staff who made themselves available for an independent provision or offering of their service to the contractor. Now, predetermined, because the contract has a start and an end time, meaning that the relationship that exists between the two of them is not for continuity for certain period of time. It could be a year, it could be 2 years, as the case may be. So, if you are a contract staff, you simply have the skills, the qualification, or the experience, and you are willing to make yourself available to offer your service to the contractor who is willing to hire you for a set period of time. That's what a contract staff is.
Oh, okay. And now, still talking about employees, we'll get to the employer later.
Okay.
In the employee part now, we have some rights and benefits of employees, which I earlier stated. Can you just highlight some of them for us again?
Okay. Generally, the rights of employee in any employment relations has to do with the right not to be discriminated against the color or race, religion, marital status, as the case may be. Meaning that irrespective of where you come from in Nigeria, if you have the required qualification to render your service to an employer, you have the right, or the employer has the obligations to make sure that you are not being discriminated against on the basis of your gender, on the basis of your nationality or identity, as the case may be.
All right, Tayo, now, what are the employee's rights when the right of an employee has been violated by the organization? How can such employee get the situation addressed?
Okay, first and foremost, the right of employee include the right to be paid agreed amounts of salary or wages, as the case may, or fee, as the case may be, for the fair job that you have done. Meaning that if an employer engages the service of an employee, part of your right is that whatever you have negotiated or agreed upon, you have the right to hand that amount of money or fee, as the case may be, as at when due, because you have rendered the job or the service that you are employed to do. Okay, but beyond that, we have rights in addition to the wages that you earn, which include right to health and safety, meaning that the employer, after giving you the job or the work to do, is also expected that he or she puts in provisions that guarantees that you are safe at work and that your health is not at risk as a result of your availability to render the service. So now, when the right of an employee has been tampered with, or the right of an employee has been jeopardized, as the case may be, the way and manner in which the employee can seek redress start with, first and foremost, the employee needs to start internally within the organization by way of making provision for what can be documented. You can first and foremost seek redress internally by writing to the employee or appropriate channel within the organization to make your grievances known to the employer so that there can be an amicable way of settling it. Now, where that is not sufficient or where you did not get what you are seeking for, okay, there is a national industrial court available where the employee can approach with evidences of what has gone wrong and therefore seek redress to the matter that has happened within the employment.
All right. About in the Nigerian Labour Act, one of the acts, part of the act says the employer has no right to deduct, to deduct the salary of the employee without first a written format, and it has to be on the grounds of probably damage or loss. Yes. So I would not want you to address that, just to shed more light on that topic.
Okay, that's just to limit the essence of employers, because employer is always seen as the one who is powerful in an employment relationship, while the employee is more or less like a weaker person in an employment relationship. So it will not be okay or accurate for an employer to proceed to deduct the salary or the wage of an employee, because that will amount to you are breaching the agreement. You have agreed to pay X amount of money for the employee rendering certain service. So at the end of that period, you need to keep to that agreement to pay. Now, where there are occasions where the employer feels there's going to be a deduction, the employee should be carried along. For instance, where an employee is absent from work without notice to the employer, usually the employer may feel aggrieved, and as a result of that, want to deduct the salary of the staff for that period. Okay, but internally it is expected that the organization is expected to have what they call policy manual or staff handbook, where the terms and conditions of employment are clearly spelled out, and where penalty, if there's going to be any, is also spelled out whenever an employee defaults in rendering the service. So where this is in place and the employee is aware that if I refuse to work certain days during the course of my employment with this employer, my salaries will be deducted. It is very unlikely that the employee will just be absent without adequate notice to the employer. Okay, in certain cases also, if the employee is sick and apply for sick leave, meaning that the employer is notified that the employee is not going to be available for a certain period of time, in that instance, the employer cannot deduct the salary because he or she is made aware, that is, the employer is made aware of the reason for absence. Any other reason for deduction outside of this may actually be subject to certain litigation, or that is, the employee has the right to seek redress.
All right, Tayo, we have a lot to discuss on this topic. We'll go on a short break now. We'll be back for more of it.
All right, thank you.
All right, at this point, we have to take a short break. But go nowhere, because we'll be back to discuss more on employment laws in Nigeria. So stay with us.
Most people don't understand the magic of a perfect skin, the allure of a well-pampered skin. We bounce from skincare products to skincare products, from spa to spa. Looking for that ideal solution. I found the solution. And it's Blemiville Skincare and Spa. My name is Neil, and I'm proud to be a part of the Blemivy family.
All right, thank you for staying with us. If you're just tuning in, this is still Legal Connect on iBrandTV, and yes, we still have Tayo Oluwole in the studio with us, and we're discussing employment laws in Nigeria. So, Tayo, before the break, we were talking about some of these laws, and but I want to ask this question: on what grounds can an employee sue an employer for wrong termination of employment?
Okay, an employee can sue his or her employer for wrong termination where he or she feels that he's been wrongfully dismissed from the work. And the provision is usually made in employment contracts on what grounds in which an employer or the employee itself can terminate his or her appointment. So where the employer proceed without recourse to what the terms and conditions of the employment is. For instance, if you're going to terminate a staff, it's expected that you give such a person certain notice, okay, ranging from a week to 2 weeks to 1 month, as the case may be. So where the employer did not keep to such notice, the employee may seek redress for wrong termination of his or her employment.
All right, now I want to bring you back to the issue of the contract staff. Okay. For instance, you have a contract that's worth 3 years, and in between, before the 3 years is over, you decide to terminate the contract. Are there some repercussions standing?
Yes, that? Of course.
Okay.
There are repercussions to that. Usually, in such contracts too, there are provisions for the grounds for termination of the contract before the end of the contract itself. So where there are unfavorable conditions, where the contractor or the principal feels that this contract needs to be terminated, he or she needs to follow what the provision of the contract is. So if the provision of the contract says that either party can terminate this contract by giving the other party 30 days notice of termination, you have to abide with that. Okay. So at time also, certain economic condition may be the basis why a contract will be terminated. For instance, if the contractor or the principal or the employer, as the case may be, has suffered serious financial loss as a result of this contract, and he or she needs to give the reason why the contracts will not continue, and the notice has to be in writing, meaning that the other party needs to know and agree to the fact that this is the condition or the reality on ground, so let us terminate.
All right, now we've been on the employee for a while now. Now let's come to the employer. Are there laws that also protect the employers? Because it seems like majority of Labour Act is mainly on the employee. So are there laws that protect the employer too, just so they don't get vulnerable along the line?
Well, the singular law that protects the employee also is expected to protect the employer. Okay. However, in addition to that, there are advocacy bodies like Nigerian Employer Consultative Association that help employers to seek certain redress. So it is also expected that Nigerian employer are registered with Nigerian Employer Consultative Association so that their rights can be protected. So where an employer operates or exists without such association, he or she may be vulnerable to certain extent. I am not aware of any other separate provision outside of the Nigerian Employment Labour Law or Act and the advocacy body, NECA, that is expected to protect the interest of the employer.
Okay.
Well, Nigeria is a dynamic state, and there are possibilities for, amendment of certain things and what have you. Okay, so as it were, as of today, this is what is on ground. there may be subsequently where there has been proven cases of the rights of employer not being adequately protected by the current employment law. So few things may come up that may warrant review and amendment of the existing law.
All right, just as a means to wrap up now, I want us to briefly talk about the HMO, because it seems like most people do not even know the rights they have as employees. So I want to talk about, because when it comes to health is important, because without the health, if your employee is not properly, it's not feeling too well, of course your work would have to pause for a while until that person is okay. So let's talk about the HMO in an organization.
Okay, the HMO are the body, registered as healthcare insurance provider. So HMO simply means Health Maintenance Organization. Okay, there is also a law that set up that, and what that means is that employer of labor in Nigeria are expected to register their employee in any of the registered HMO. However, even though there has been welcome responses and sign off into this HMO scheme of a thing, as it stands today, the full backing of the law is not yet there. What I mean by that is the final signing of this law to make it perpetually binding is not yet there. So that gives a loophole for certain employer to dodge or to escape this. But at its were, it is understandable that it is there in principle that every employer of labor is expected to make provision for the health insurance of their staff. With government or political will power of our government, everyone believes that it is the right thing to do or the right way to go, and there is need for a final effectual signing in of this scheme into law.
Tayo Oluwole, you are a human resource consultant, and as a human resource consultant, I'm sure you must have come across a lot of complaints from employees about some of these things are not put in place. So you said that the HMO is not yet backed up by the law. Is there a reason? Because some things like this are really important, and do you think there's a reason for this?
Well, there will always be reason anyway. Yes. Okay, but to the best of my knowledge, I think there are a few technical issues regarding the scheme. Okay, and I will also say that there is also a perceived weakness of the political will to exercise this. Because if you notice that there are technical flaws in certain scheme, is to call the party involved and go and address this, go and address this, go and address this, and then you eventually sign. Okay, so really we shouldn't give excuse for why it has not been signed or why it shouldn't be signed into law. It is what is good, we should sign into law. And if government had noticed any loophole, any technical fault in it, is to call the stakeholders in that to correct or make certain amendments and sign to law. So what the feeling you will generally get among the populace or the employee is the fact that they are expected to be protected by health insurance through the HMO scheme. Okay. So the employee like it. Does the employer like it? Yes, of course, also. Yes, because as it were, if your employee are healthy, you also have the peace of mind. So what that means is that a healthy workforce makes healthy organization. Correct. As much as possible, you want to avoid man-hour loss due to health and what have you. So employer understands this, and they will readily be willing to embrace it when it is eventually signed into law.
All right, finally, Tayo, I know the employers are entitled to some kind of leaves, like the casual leave, the annual leave, employee rather. Thank you. So you mentioned some of this leaves that the employees are entitled to.
Okay, generally there are what we call annual leave, which is vacation period for employee. To qualify for annual leave, the provision are that an employee must have worked for a period not less than 12 calendar months, and he or she can apply and proceed on annual vacation. Aside that, there is also a provision for what we call maternity leave for female employee who became pregnant and need to go have their childbirth. So that is also expected, or is in the Labour Act. Some organizations, especially the bigger ones, also made provisions for paternity leave. Okay, I know that may sound new to you or to some people in Nigeria. Well, I'm not aware there's been any legal provision for paternity leave, because it's expected, or the argument among employers is men are not expected to get pregnant, so why the provision for paternity leave? Okay, but the proponents of paternity leave are saying that when a woman put to bed, the stress of that baby delivery is not only on the woman.
Husband.
The husband is also part of the care, and he needs to help the wife at home to take care of certain things so that the stress can be less for the wife. So currently, what people are doing is, men in particular are taking their annual leave anytime their wife put to bed, to be able to stay with them for weeks or days, as the case may be. So in addition to maternity leave, there is also provision for sick leave when an employee became sick while in employment. These are statutory or expected to be observed from time to time.
All right, thank you so much, Tayo Oluwole, for being on the show today. We had an amazing time discussing with you. I'm sure the viewers are having amazing time too with you. Thank you. We hope to see more of you on our shows. Yes,
my pleasure.
All right, thank you. Okay, now we have to call it a wrap on the show today. Don't forget, in the words of Tayo Oluwole, he says a healthy workforce makes a healthy organization. My name is Margaret Opera. See you next time.